Welcome back. Before we continue, in her judgment, Judge Masipa herself raised a very serious concern that witnesses may have been influenced by watching and hearing others give evidence before them. Let us just have a look what she had to say in her judgment.
The fact that this case attracted much media attention, especially soon after the incident, and the fact that it became a topic in many homes also did not assist. Almost every witness who was asked under cross-examination if he or she had followed the news relating to the events of 14 February 2013 or the bail proceedings or the trial proceedings responded positively. A few witnesses considered that they discussed the case with others before they took the witness stand.
See, that's what I wanted to ask. She's raised a really important question.
Indeed.
And how do you deal with that? Even in your case of taking a common case, if that was televised and you went home, the witnesses may also hear.
Absolutely, and that is one aspect that Mlambo JP did not deal with. Although
rather important aspect, I would say.
Absolutely, when Oscar said the pressure will be unbearable on himself and his witnesses, and he raised the question of witnesses having access to evidence that has already been given by others. And we know that that's a basic principle in trial matters, that witnesses should not have access to evidence already tendered in court. And the judgment, as Judge Masipa indicates, shows that the courts in future should be very careful when crafting the parameters of broadcasts, live or audio. And I don't know if it will be able to cure that problem, because the open trial, the open justice principle, basically, as we have advanced it, means that witnesses who have not testified have access to evidence that has been given already.
You see, that's the point I want to ask you. When you're dealing in cases, very often a lot of a criminal trial, inordinate amount of criminal trials, often turn on cross-examination of a statement that witnesses are given, and then the counsel says, but now you're contradicting the statement. And often judge may turn around and say, oh, you know, most of us in the heat of a moment may say A, now we're saying B, it's upon reflection. There's hardly a criminal trial one knows of where the two meet so that, you know, count is taken. But in this particular case, you'd kind of sort of wonder whether the evidence has now been tailored because the witness has been sitting at home listening to what the previous witness and the line of cross-examination. Now, you can't take account of that.
Well, I think two responses. The one is that's not a product of televising the trial. In any high-profile trial, there will be widespread publicity.
Oh, but you've already said it's not quite the same.
It's not quite the,
not quite the same as saying, seeing the defense counsel put somebody through the grill from A to Z.
Sure, but it's a difference of degree, not kind. And I think
significant degree.
But still, in principle, one has to take into account that with Davani, if you want to follow, if you're a witness, you can follow on Twitter what has happened to a previous witness. You can read, you can listen to 702 that afternoon and find out that the taxi driver collapsed in this or other degree. So I accept that it is a different degree, but one still has the same problem in any high-profile trial. Second point is Nugent's judgment in MIDI TV. What Nugent said in that case, where ETV broadcast a documentary with an eyewitness to the baby Jordan murder before the eyewitness gave evidence, is actually, if a witness wants to lie to the media and then tell a different story in court, it's in the interest of justice that that gets exposed. So turning on the head the point of saying, you know, let the media stay away from witnesses. What Nugent was saying...
I understand what Judge Nugent was saying, but what I'm asking is a slightly different question. It's the witness seeing the way this is working and then tailoring their evidence ever so slightly to just be more credible than they might otherwise have been.
And a skilled cross-examiner will expose
or even the situation that you can't be sure whether they're telling you this because they saw this on television. In other words, in the Pistorious cases, all this business about the screaming you know, and you couldn't be sure if the witnesses were telling you this because they'd heard the line that had been previously raised, or whether because they'd seen it on television. I mean, that's what I'm probing with you.
But for me, the answer is to manage your witness. If you
How do you do that,
If you
might I
Gerry
ask?
Nel, you say to your witnesses, don't follow this thing on TV. If I want you to be the most credible, the most independent witness you can be,
In this day
you
and
mustn't
age.
follow this on TV. And certainly I'm sure Barry Rue would have tried to tell his witnesses the same thing. It's throwing the baby out with the bathwater to say that because witnesses might watch on TV and then tailor, we need to stop broadcasting entirely. And because, of course, the logical extension of that argument is then we must stop Twitter in court, and actually we must even stop any form of reporting until the
No,
trial
I
is
accept
over.
that. I'm just talking about it in technicolor, Professor. I mean, when Judge Masipa says a few witnesses concede they discussed the case with us before they took the witness stand, or they had followed the news relating to the events of February 2003, the bail proceedings, the trial proceedings, etc., and they responded positively. That is problematic.
It is, but I think we have to recognize that that may well happen, and probably does, in every single case. That families who witness an incident may well discuss it amongst
No,
themselves.
look, I understand a father. Look, if it's a mother and a husband and a wife,
yes.
I mean, for goodness sake, I mean, it's ridiculous to suggest that two people woken up in the middle of the night are going to say,
discuss it.
"Ooh, we're going to be witnesses now. We better not talk to
Yes,
each other."
yes.
That's nonsense,
Yes.
right? But I'm talking about unrelated witnesses.
Yes. But I want to go back to the point that the courts do have in place, and the judge is on guard to detect whether in fact people have been discussing matters and are in fact tailoring their evidence. And those safeguards simply need to be applied to the considerations here. Firstly, of what's already in place, whether people are following on Twitter, but also then extending that to whether they've been following a broadcast.
But the broadcast, I accept that. I mean, you can ask somebody; they could lie. You've got no way of knowing.
Sure.
And if they're a clever witness, I accept. Many witnesses will be caught out, but there will be some witnesses who could sit there, look at the cross-examination, and say, "Aha! I know where this is going, and I know how to deal with that."
It is true.
I mean, you can't deny that is a problem.
But those witnesses, those naughty
He's
witnesses...
very keen. At least
Yeah,
you made a
yeah.
concession. He makes no
No,
concession.
because those witnesses, Judge, will have done the same thing in a trial that's not broadcast. They will have keenly listened to every news
Oh, but you're
item.
helping them enormously.
You know.
I mean, they see the whole thing.
Well, they hear, because remember the lay witnesses, Mlambo says in his judgment, I'm giving audio for lay witnesses. I'm not giving TV. TV is for the experts and whoever chooses to do it. And of course, interestingly, two of Oscar's witnesses who didn't have to be televised chose to be televised.
Yeah, all right.
So, you know.
But I'll come back to the witnesses who refused to testify, and that's another matter, but I've got to take a break first.